Good evening, everyone. My name is Vanessa Schoeneckau and I'm the CEO of Geelong Regional Libraries. And I'd like to welcome you to tonight's webinar, Challenging Our Current Rule of Law in Rape Cases. Thanks everyone for joining us for what will be a very thought-provoking discussion tonight. And Geelong Regional Libraries is proud to present tonight's webinar in partnership with the Geelong Women Unionist Network and March for Justice Geelong. I would like to start by acknowledging the Wadawurrung and Eastern Maar original owners of the lands on which our library service operates. We pay respect to Wadawurrung people and Eastern Maar's elders, people past, present and emerging. We acknowledge and celebrate the First Nations people of this land as the custodians of learning, literacy, knowledge and story. I'm sorry that we can't be together tonight, although following the easing of restrictions for regional Victoria recently announced, I am very pleased to be able to reopen, that we've been able to reopen our libraries to the public once again. And whilst our doors are open, we're also continuing to offer click and collect services. And you can find more information about that on our website or by calling or visiting your local library. Don't forget that as a member, you can always explore our extensive e-collections, including audiobooks, ebooks, film streaming, and much more from the comfort of your home, which I think is important to everyone right now. Our draft library plan 21-25 is currently on exhibition, on public exhibition. So please indulge me whilst I just let you know about it, because it's on our website until Thursday for community feedback, and it maps out our role in building community resilience and our community's recovery from the pandemic as we think about the next 4 years. It responds to the challenge, how do we work together through short-term uncertainty whilst planning for our libraries, services and programs in the future? And this requires bold thinking so that we can prioritise our hard to reach and vulnerable communities in our region and find new opportunities to take our services out into the community and beyond the four walls of our libraries, like tonight. And so a good reason for you to join our local library and your local library, if you're not already a member, a key action in our library plan is that we advance regional knowledge in and constructive debate around complex challenges such as reconciliation, climate change, social equity, population growth. And so I do encourage you to become a member if you're not already and support your local public library. And now it's my very great pleasure to introduce you to our facilitator for the evening, Glenda McNaughton. A feminist since the early 1970s, Glenda has found that when women come together, they empower each other and they affect change, as we are seeing right now in Australia. For more than 40 years, Glenda has sought to change the structures, institutions, and discourses that she believes violate women's rights and their experiences. Recently, that work has been as a member of the Geelong Reclaim the Night group. And for over 25 years, Glenda worked with young children, their teachers and their parents, both in Australia and overseas, to effect change in the way the politics of gender, race, class, ability and sexuality could be challenged in early childhood institutions. I would now like to welcome Glenda, who will in turn introduce our guest panelists and facilitate the rest of this evening's event. And I'm very much looking forward to tonight. Thank you to all of you. Glenda, thank you, and over to you.
Thanks very much, Vanessa, for that introduction. As facilitator of this evening, I'm, like Vanessa, looking forward to the event and the conversation very much. I'm coming to you as facilitator via the magic of Zoom from the Ballaween this evening. The Ballaween, many of you may also know as the Ballerine Peninsula near Geelong. In Wadawurrung language, Ballaween means where we lean on our elbow, that's the Balla, Beside the fire is the wean, while looking out over the sparkling sea. It's an amazing way of thinking about where I live and understanding the deep ways in which this place has had such a long history through the traditional owners of the land. It's a place I've worked and lived for the last 15 years, a place that is the traditional lands of the Wathaurong peoples. And I would like to take a moment to pay my respects to their elders, past, present, and emerging, and to any Aboriginal elders and other communities who may be participating in this evening. Having said that, I have some housekeeping to do before we start the evening. I want to thank everyone for joining us tonight. I gather we have 68 people registered, which is a fantastic number to have registered, and it shows the deep interest people have in the conversations that we're about to engage in tonight, and the significance of those to all that are joining us tonight, I suspect, is intense. The brief housekeeping reminders before we begin our discussion. You can participate in this live webinar by clicking on the Q&A button, which for many I think is at the bottom right hand of their screen. And you can type a question or a comment there. We'll be keeping a watch on that tonight, so we'll know and be able to respond, hopefully, to what emerges in the Q&A function. I gather it's a pop-up function if you're using an iPad or an iPhone. Also, the webinar is being recorded, and if you would like to watch the discussion again or perhaps recommend it to friends, family or colleagues, it will be uploaded to the library's YouTube channel within the next couple of days. So that's a great opportunity to engage more broadly with others in this discussion. With the housekeeping out of the way, I have great pleasure in introducing our first speaker tonight, Adele Welsh. Adele comes with a wealth of experience that's really critical to the discussion tonight. She's a highly experienced social and community services worker with very specific skills in child and family welfare and family violence. She's also an incredibly active Australian Services Union member, as you'll learn in a moment, as co-convener of the Geelong Women Unionist Network, a Geelong Trades Hall councillor, and in 2019 to 2021, she was president of Geelong Trades Hall Council. Adele is also very committed to family violence and women's social justice through her activism. She doesn't just talk the talk, she walks the walk very much. She played a key role in Geelong's well-attended inaugural March for Justice, which some of the participants tonight may have been part of. She's participated in union delegations to Canberra to lobby MPs for paid family violence leave to be included in the National Employment Standards to ensure all women have access to paid family violence leave, a very important initiative. Adele, through all of that hard work, has previously won the Australian Services Union's Women's Tile Award for outstanding service to Geelong, to women and the union, and was Geelong Women Unionist of the Year after she and her fellow members and delegates won a very lengthy and challenging EBA campaign that I remember well, that led to significantly better pay and conditions at her female-dominated workplace. So with that background, Adele, welcome, and I look forward to your contribution to tonight's conversation.
Thank you so much for that, Glenda. I'd also like to acknowledge the traditional owners of the land I'm zooming in from tonight, the Wathaurong people, and pay my respects to their elders past, present and emerging. And I'd like to extend that respect to any Aboriginal people who are here with us on tonight's Zoom. This land was stolen, never ceded. It always was and it always will be Aboriginal land. I'd also like to acknowledge that Aboriginal women carry a higher risk burden for experiencing sexual assault, rape and family violence, and that they also face added barriers when they do try to seek justice. So tonight we're going to be talking about sexual assault, rape, family violence and justice for women. So if tonight's discussion raises any issues for you, or if you need any support at all, you can contact the SAF Centre. And there's also the 1800 Respect line, which is a 24-hour support line on 1800 737 732. And additionally, Aboriginal women can also contact JIRA on 1800 105 303 during business hours. So Geelong Women Unionist Network, or GWUN as we're known, are really proud to bring tonight's forum with you, along with Geelong Regional Libraries. GWUN were founded over 15 years ago by the now member for Geelong, Christine Cousins, to recognise, honour and celebrate women's significant input into Geelong Trades Hall and into the wider union movement. And we're really honoured to have Chris on the Zoom with us tonight, and we thank her for her ongoing support for women and for the trade union movement. So GWUN are an unfunded group of rank and file union women, and we do grassroots campaigning on issues such as family violence and equal pay that are more likely to affect women. And we're especially proud that when my union, the Australian Services Union, won the very first paid family violence leave clause in the whole world at the Surf Coast Shire here in Geelong, the ASU delegate who really worked to push that clause through was also one of our GWUN members. So we also, as Glenda said, organised this year's Geelong March for Justice. And when we saw the extent of the anger and the emotion in Geelong, we realised that we needed to do more on this issue. So that's how we came to run tonight's forum. So globally, 1 in 3 women are affected by physical or sexual violence, and it's a hugely significant issue for our community. In 2015, violence against women cost the Australian economy $22 billion. And half of that cost, $11 billion, was carried by victim survivors. And because Aboriginal women, pregnant women, homeless women, and women with disabilities are so underrepresented in the statistics, it's estimated that we could add another $4 billion to that cost. So all forms of violence against women happens in the context of sexism, misogyny, unequal gendered relationships between men and women, unequal pay, disrespect for women and the work that women do, and lack of respect for women's role in society. And women experiencing financial hardship are more likely to experience sexual assault. So as well as law and systems reform, we also need to be working on preventing violence and improving women's economic standing. And workplaces are uniquely placed to play a key role in creating change and justice for women, because they can introduce policies to reduce and eliminate sexual harassment at work and take steps to address the gendered pay gap. The gendered pay gap is highly complex, but some contributing factors are that female-dominated industries are seen, such as nursing, admin, early education and care, and teaching, are seen as women's work and as caring work, and therefore as less value than traditional male-dominated industries like construction and blue-collar trades, which are seen as more important and more worthy of higher pay. So women are more likely to take time out of paid work to have and care for children. So lower pay combined with less time in paid work affect women's lifetime superannuation savings, leaving them to retire into poverty and to become more vulnerable to homelessness and violence as they age. And we know that violence against women escalates during disasters and catastrophic catastrophic events such as the global pandemic and last year's bushfire emergency. And women lost more work and more pay during the 2020 lockdowns than men did, further increasing their vulnerability to violence. The most common perpetrator of sexual assault against women is an intimate partner or a person known to the victim. And 70% of sexual assaults happen in a home. And sexual assault and rape has a very strong link with family violence, and it often sits alongside the put-downs, the controlling behaviours, and the physical and psychological abuse. So 1 in 3 sexual assaults that are reported to police are family violence related. And sexual assault is recognised as a key red flag indicator that the victim survivor might be at higher risk of a serious assault or homicide. Reporting to police can be very difficult and challenging for lots of women, and conviction rates are very low. Our current court system is an adversarial system where the burden of proof sits with the prosecution. There's often no witnesses, limited evidence, and it's usually her word against his. And at times, the survivor can feel as though their life is on trial. And because the perpetrator is very often known to the victim, it could be her boss, her partner, a relative, or a community member. So in seeking justice, survivors can risk being ostracised from their family, their place of work, or their community. I think my time's just about up there. So before I hand back to Glenda, I'd just really like to thank everybody for Zooming in tonight. And if anybody would like to be more involved with GWUN, you can like and follow us on our Facebook page, Geelong Women Unionist Network, or contact Geelong Trades Hall on 52 211 712 and ask to be added to our email list. Our next big event will be our conference on October the 30th, where we'll be talking about the impacts of the global pandemic on women, issues in our health system, climate change as a feminist issue, and how to run a meeting without being spoken over. So our conference will either be online or in person, depending on COVID restrictions at the time. You don't have to be a union member to be part of GWUN. You just need to be a woman who wants change. Thank you so much, everybody, for Zooming in tonight. Thank you to Geelong Regional Libraries for hosting. And thank you so much to our amazing speakers who are going to share their knowledge and experience with us. Thank you so much, everybody.
Thanks very much, Adele, and particularly important to paint the bigger picture of what violence against women sits amongst. And I think towards the end, as you were highlighting the multiple survivor risks that women face, it's a good jumping off point for where we're heading next. So thanks for that. I've got great pleasure in introducing Tony North QC next. I'll try and keep the introduction brief so Tony has lots of time. But Tony comes to us with enormous experience at one of the things that tonight is really targeting, and that's how we can change the current rule of law in rape cases. Tony QC is a former judge of the Federal Court and the Supreme Court of Australia, the Australian Capital Territory. In 1995, he was made judge of the Federal Court of Australia, where he served until his retirement in 2018. During his time as judge, Tony presided over many significant cases that may be familiar to many of you listening, including some of the first native title cases and his ruling in favour of the asylum seekers on board of the Tampa. He was appointed chair of the Victorian Law Commission in 2019, and that's his depth and breadth of experience in the law that we welcome him to tonight and look forward to his views on the topic we're trying to explore tonight. Welcome, Tony.
Thank you. Thank you very much, Glenda, and thank you for the invitation to speak tonight. I come to you, as you said, in my capacity as chair of the Victorian Law Reform Commission, and the Commission has just completed an 18-month inquiry into the justice system response to sexual offending. That has involved us in a large team of researchers, firstly producing a consultation paper setting out the questions we think that are raised by the topic, then by consulting with a wide range of people, you know, from courts to police to advocacy organisations and individual victims, receiving a vast number of written submissions, and then the team put together the final report. Now, if I look rather tired and drawn, it's because the draft has just been concluded. It's due to be handed to the Attorney General on the 20th of September. And you can just imagine it's a 600-page report. It's the work of the team. It's also vetted by the 9 other commissioners that form the commission. So it's a huge task, and I think you'll find when it's ultimately made public that it is a roadmap for addressing this very, very difficult area. And, you know, it's too easy to sloganize about the way to address the problem. It's too easy to say what a serious problem it is. As Adele has said, I think the figures we use are 1 in 5 women have experienced sexual assault in their life after age 15. But what we've done is we've canvassed a whole range of methods to address the problem. And I want to quickly go through them to just give you an overview and to try and dispel the idea that there's a magic wand to address the issue. Having said that, I think we will, you'll see, produce a way of going forward which will make a difference, albeit that I have to acknowledge it's something that will take time. So let's start with some figures. Over 80% of sexual assaults are not reported. So that gets you to ask the question, why? And that, I'll return to that in a moment. That's one of the things we looked at. Of those small percentage that are reported to the police, only 30% go on to some legal action. Well, why? We asked why. What's the reason for that attrition? Why is it that the police are determining not to proceed, or the OPP, the Office of Public Prosecutions? Again, I'll return to how we address that in a minute, but just to set the scene. Okay, then of those that go on to legal action, the large percentage of them end up with guilty outcomes. Now, this is something that's sort of not well understood in the figures that are often tossed around. I mean, a well-worn figure is 1% of sexual assaults end up in a conviction. That's really an unrealistic sort of a figure. What we have to look at is, of those that go to trial, of those where the police charge someone, how many get convicted in the end? And the figure for the magistrates' court is 83%. The figure for the county court is 98%. And that is, the large bulk of those figures are people who plead guilty once charged. Of the contested cases that go to court, it's about a 50-50 outcome. So 50% of trials And these are the ones we hear about where we have this, you know, awful cross-examination and complainants are humiliated and made to feel like dirt. In that area, 50% of those that go to court end up in convictions. So it's a bleak picture. It's a bleak picture, I think, particularly because of those, you know, 80% of cases which never get into the system. So there are 80% of sexual assault perpetrators out there in the community who never have any accountability. And that, I think, is one of the very serious difficulties. So let's now, with the background of those figures, let's go to the things that we were told. Now, bear in mind that I can't, of course, make public what's in the report, but I can tell you what we heard. You'll ultimately hear what's in the report, but it's important for me to emphasise because, you know, obviously I report to government and that's not yet happened. So I'll try and give you a survey of what came out in our inquiry. So going back to the 80% not reported, we had a look at how you can, why is that? Well, there are lots of reasons, and I don't need to rehearse them, I'm sure, for you. But one thing we thought that that people told us might improve reporting would be some online system so that a person, a victim survivor can, in her own time, in her own place, go online. I mean, by far the largest proportion of victim survivors are young women. Going online is something well known to them and probably the first thing that they reach for. So query whether that would make a difference. Obviously, community education lies behind all of this, a change in culture so that little boys and little girls at school know that if such an event happens, where to go and what to do, and that it's no shame and it should be done. But, you know, that's obviously a very big picture sort of project. Now, the next step is, what about the fact that only 30% go through the police net? Victim survivors, this is a point at which victim survivors voice much dissatisfaction. They go to the police, they take that big decision, and then some policeman says, well, I don't think there's enough evidence, or I don't think you'll be believed, so we're not going to go ahead. It's the cause of a great deal of angst. And one of the proposals that was put to us was that there should be a sort of independent review of the police or OPP decision not to go ahead. So that's one of the things we looked at. And I have to stress as I go through all these things that the answer is multifactorial. So, you know, it's no use having a perfect trial if you have a bad experience with the police in getting to the trial. So that might address the attrition issue. Then when you get to the next stage, one thing that became very clear to us is that that justice looks different to different complainants. Some complainants want a trial, a criminal trial, but they need to know what's involved. They need to know the delays, the process of cross-examination. And so there are other options that suit some people. One of them, for instance, is give away the whole idea of a trial, cross-examination, delay and all that. Restorative justice, where the perpetrator and the victim sit down to try and work out a way forward, to mend, to heal. Now, it's obviously going to be suitable only in a small number of these sorts of cases. But, you know, where there's an intrafamilial sexual assault and daughter doesn't want grandpa or father or uncle to go to jail, but wants an acknowledgement of what happened and the harm and the hurt and the destruction to her life, I say if you help 6 people through that process in a year, it's worth doing. And there've been some great successes using that method. But there are others. There's truth-telling, that is the ability to be believed before an authority figure like a compensation tribunal. We were told of some novel ideas about making civil litigation more available by having state support of funding for civil litigation, where the standard of proof is not beyond a reasonable doubt, but on the balance of probability. So it's easier to get a result. So they were some of the alternatives that we looked at, so that victim survivors might be given options other than the criminal justice system. But then the question arose, we were told so often that in the disturbance of the moment of the events, women are confused, they're overborne, they're distressed. And in the UK, there is a system of what they call victim advocates who are appointed to walk with the woman through the whole process, provide the options right from the beginning. So we looked at whether that would be a way of making the experience better for victim survivors. And it seems to have a lot of promise, because you would be able to, for instance, at those critical points, like where the police make a decision not to proceed, you'd have a victim advocate who could explain what has happened and why, and perhaps give the woman a way of challenging that decision, which otherwise she may not know about. So that's sort of one example. Then we get to the justice system itself. Those brave women who decide to go ahead and go for a trial. Of course, I can emphasise maybe 2 points about the trial system. There are many others, but that we looked at. But the one issue that has come up a lot in recent times is the idea of the definition of rape, of consent, and whether the law about consent is making it too hard for victim survivors to succeed in the court. And we heard some different views. As a result of an announcement in New South Wales in the course of our inquiry, to the effect that New South Wales was going to draft legislation to implement an affirmative model of consent, we had a look at that issue. And there are 2 views about the value of an affirmative model of consent. Some people say the current law actually reflects such a model and nothing needs to be done. Others say it should be changed. And it should be changed. No one's actually drafted it yet. And of course, the devil is in the detail. But essentially what an affirmative model would look like would be to require the accused to establish that he took steps to ascertain whether there was consent. I think there's a strong argument that the current law already requires that. I won't go through the detailed sort of legal elements of why that's so, except to say to you a few points. One is that consent is defined in the Act of Parliament which makes rape an offence as free agreement. Consent in the same Act of Parliament is said to not exist where a person is intoxicated, where a woman is intoxicated and unable to give consent, or where she does nothing or says nothing to indicate consent. And there's a long other list to a similar effect. But my point is that the law as it stands requires free agreement and does not admit of consent where, say, a person is asleep, a woman is asleep. Now, the problem that came out in our inquiry was not that the law was deficient, but that it wasn't actually being administered by the courts in accordance with what's written. And that is because we heard this so often of the culture of the legal profession, judges, barristers, prosecutors, not all of them, but as long as you have one of them in the courtroom, in one of those roles, you've got a problem. And so we face this sort of difficulty that in order to get rid of that culture, which is obviously a long-term thing, will take years. But I just ask you to imagine if you've got a judge who was brought up when I was, of my age, in the era when the rape myths were rampant and hasn't really changed, how is he going to run a trial trying to appreciate that really the focus is on what the accused said or did? So there's a real issue about whether there should be a change in the law or not, or whether, and this was argued before us, whether the answer to the question of consent is to mandate, that is require, judges and barristers who participate in these trials to be educated in the law as it is, and not be permitted to either adjudicate a trial like that or act as a barrister unless they have some sort of ticket or certificate that shows that they've had that education. And it sounds a bit Big Brother-like, but let me tell you that it is the system in the UK where judges at least have to hold a ticket, because it is seen that understanding the dynamics of sexual assault is a very specialised and separate sort of area of understanding.
Tony, I just need to come in as facilitator and say we need to sort of wrap up, even though I know you've got a wealth of information to share that people will be interested in.
Sure.
Just
Okay.
to give the other speakers some time.
I'll do that. And all I can tell you is that, of course, I'm carried away by the fact that our report is 600 pages, and I'd love to tell you lots more. But I guess the bottom line about consent is that there's a strong view that the law is fine, but it's the administration by the legal profession that's the problem. And we looked at a solution by way of mandating judges and barristers through education. Thanks very much.
Thanks, Tony. There are many questions that what you've been sharing raises, and I think people will be anxious to see that roadmap as it emerges when we can see the report. Thank you for your contribution. I think Nerida follows this contribution very well, because she'll be talking about restorative justice in more detail. So if I can introduce our next speaker, Nerida Lewis. Am I right, Nerida Lewis? Lewis. Nerida has a wealth of experience around issues of restorative justice. She's currently a restorative justice convener, and she's facilitated many processes in response to different types of harm, including serious crimes. She was centrally involved in establishing the Open Circle Restorative Justice Service, and she joined the Centre for Innovative Justice in 2016 to coordinate the Centre's Restorative Justice Conferencing pilot project. She says of this experience that it allowed her to witness the transformative potential of restorative justice and what it can offer people affected by serious harm. She's committed to expanding the availability of that process so that more people can benefit from it. She's previously practiced criminal law, working primarily with people with cognitive impairments and serious mental health issues. And she's also, as a lawyer, supported victims and survivors of sexual offences to make applications for victim assistance. She's an active researcher and publisher on these issues. And Nerida, I invite you to share your thoughts with us on our specific topic tonight and how restorative justice might contribute to changes. Thank you. That's all yours.
Thank you so much, and thank you to the organisers for inviting me to be part of this fantastic panel and for creating this opportunity for this fascinating conversation. Before I begin, I'd like to acknowledge that I'm on the lands of the Wurundjeri people tonight. I pay my respects to their elders past, present and emerging, and extend that respect to any Aboriginal people who might be joining us tonight. And as Adele said so eloquently, I also want to acknowledge the disproportionate effect of sexual violence on Aboriginal women, compounded by the effect of ongoing colonisation. I'd also like to acknowledge any victim survivors of sexual violence who are here with us tonight, acknowledge their courage and resilience. And also what I neglected to add in my bio is that I'm also a proud member of the National Tertiary Education Union. And it's lovely to be here with fellow Unionists tonight. So I manage a service called Open Circle. We're a restorative justice service. We're part of RMIT University and part of the Centre for Innovative Justice, which is a centre started by former Attorney General Rob Hulls. After he left government, he started the centre to continue the work he was most passionate about, which is providing therapeutic interventions in the justice system and really trying to find ways of doing justice better and finding ways of amplifying the voices of people who are directly experiencing justice processes. So we're a practice arm of the CIJ. We offer restorative justice processes. We are currently offering processes that respond to sexual violence. And we've been doing this since we opened, and there is a demand there, is what I'll say. There is a demand from victim survivors who want to take part in restorative justice processes. And that's what guides us to do this work. People want to do it. A really, really brief summary of restorative justice. Restorative justice, I think of as it's a philosophy, and it's also a way of talking about certain practices. So it's a different way of thinking about harm or crime or a wrong. So, under criminal law, the criminal law asks questions like, has the law been broken? What can the evidence establish? What punishment is appropriate? Restorative justice asks different questions. It asks questions such as, well, who's been harmed? What do they need? How do we make it right? And whose responsibility is it to make it right? And the restorative justice practices embody that different way of thinking about harm. And as Tony's mentioned in his presentation, often that restorative justice practices involve a dialogue between people, and often between the person who's been harmed and the person responsible. So in this context, between a victim survivor of sexual violence and a perpetrator or a person responsible, that's certainly one form that dialogue can take. We also hear from victim survivors who want a slightly different scenario. So commonly we'll talk to people who they're not interested in meeting with the perpetrator, but they do want our assistance to talk to other relevant people, for example, members of their own family who may not have supported or believed them when they reported or when they disclosed. It might be that they need to go through a process with those family members, which might be about being heard and validated. It might also be about sorting out really practical arrangements, such as, you know, the perpetrator might also be a family member, and the victim survivor just says, look, I just want him to not be invited to family Christmas anymore. And we can help them with a process that supports them to talk to their family about that. So in terms of how restorative justice might benefit victim survivors, if we think about what, sorry, I'll reframe that. Research says, and just also my practice experience, that recognising that everybody is different, all victim survivors are different and have different needs, there are certain themes that emerge that are commonly what people want, and a lot of this research is specifically on the needs of victim survivors of sexual violence. What does justice look like? It's different for different people, but there are common themes, and the ones that I work with are voice, validation, accountability, prevention, and relationships. So the need for voice, and this is talking about, what does that person need to feel like justice has been done? It's different to the material needs somebody might have, a need for housing and financial security. These are what we call justice needs. What does this person need to experience to feel like there has been a response to the violence I experienced? So voice, for some people, it's a very strong need to tell their story, the story of what happened and how it impacted them. A need for validation, to feel believed, listened to. Accountability, so to really know that the person responsible understands the gravity of their conduct and understands that it was wrong. Prevention, and that can be tied to accountability, that they want to make sure they've done what they can to make sure this doesn't happen to other people. Relationships, a need to address the effect of the offending on relationships. It doesn't necessarily mean they want to have an ongoing friendly relationship with the perpetrator. It might be other relationships like other members of their family, or it might actually be about addressing with the perpetrator, we're from the same community. If you can't come to a social event that I'm at, I want you to leave. If you see me in the supermarket, I want you to leave. So different needs. And if we think about the criminal justice system and its capacity to meet all of those needs, it's quite limited. And I won't go into detail, but I think everybody here understands the limits of the justice system to really provide all of that for each victim survivor. And that's not so. I think, Tony said there's no magic wand, and I really agree with that. I'm not here saying that restorative justice is a magic wand, and I'm not saying it should replace the criminal justice system either. I think that victim survivors who want to access the criminal justice system should be supported and encouraged to do so, and the other measures that Tony's talked about absolutely need to be explored. But I think it is about putting as many options on the table for victim survivors so that they can choose what best meets their needs. And Tony's given us a really in-depth overview of the attrition rates in response to sexual violence. We just know that for women who choose to report to police, you know, relatively low numbers will see a conviction. And then there are all those women who, for very good reasons, choose not to report. And, you know, members of particular communities such as Aboriginal women, other communities who are over-policed, they don't want, you know, there are additional barriers to reporting. And yes, those barriers we need to continue to address, but we also need to acknowledge that some victim survivors are just not going to report at the moment, and there need to be other options available to them. I'm going to keep it reined in because I'm very passionate about this topic and I can go on and on about it endlessly. But what I might touch on are just some concerns that people, I think, rightly have about offering restorative justice for sexual violence. And a big one is, well, does this re-privatise sexual violence? You know, feminists such as yourselves here tonight have worked tirelessly for years to make the criminal justice system recognise sexual violence as a crime and something that should be dealt with publicly. Does restorative justice push it back into the private realm? I think we need to be conscious of that, but I think if it is an option as well as the criminal justice system, then it's about respecting victim survivors' choices. It should never be, you know, it should never be a reason to prevent access to the criminal justice system for those who want it. And I think it just comes back to that reality that for a large percentage of victim survivors, the criminal justice system either doesn't deliver what they're looking for, or they can't access it anyway. So rather than you know, re-privatising, I feel like it's an option that adds to what is there for victim survivors, rather than pushing this further, sexual violence further under the carpet. Another question that I think, and those of you who work with victim survivors, you know, this will be at the forefront of your mind, and it's always at the forefront of mine as well, is you know, what if the victim survivor is re-traumatised by participating? And some people, when I talk about the work that we do, are quite horrified and think, well, why on earth would you invite a victim survivor to sit down with a perpetrator? That just sounds like a recipe for trauma. And I think it's all about the way that it's done. Our model is focused on meeting the needs of victim survivors. We do incredibly careful preparation with all participants. We have very skilled practitioners who've worked in the sexual violence sphere for many, many years. And I think another key point is that it's always got to be voluntary. So this is for victim survivors who feel that they need to do this. It's never something that anybody should be forced to do or coerced to do. But yeah, if it is voluntary and it is done properly, then for me, the most persuasive argument is that victim survivors want to do this. And I feel like we need to respect that, and we need to set up proper safeguards, of course, and not do this work lightly. But we need to recognise victim survivors as the experts in their own life and their own healing and their own sense of justice. Yeah, I might leave it there. Thank you.
Thanks, Nerida. I think that followed on very nicely as a jumping off point from one of the key issues that Tony raised, but pointing also to the complexities of just one of the pathways forward. I'm going to introduce two people who work with victim survivors in a moment, but I just want to alert everybody to the fact, as you probably know, we're running a little over time. We're not going to cut off Kerry and Sue because their perspective is very important. So for those of you who can stay online with us, please do. And there is an opportunity. We are going to allow some time for the audience participants to ask questions. There is a little Q&A icon on your screen where you can click on that and write us a question, and we'll pass it on to the relevant panelists. So there is an opportunity still for questions. So we hope those of you who are online will be able to stay with us. We have a number of participants who've stayed with us to this point. So we hope you'll stay to hear from Kerry McFarlane and Sue King, who will be speaking next. They're both from the Barwon Victims Assistance Program. I'll introduce Kerry, and Kerry's going to introduce Sue. Kerry's had 20 years experience in the human services field and has been in her current role for 5.5 years. A key part of her role is to provide support to victim survivors of serious crimes against the person. And Kerry's had opportunities within this role to educate police members, the Office of Public Prosecutors, and other court officials in reducing the ongoing victimisation of rape victims and survivors. Kerry's had previous experience in child protection, supporting sexual assault victims, out of home care, and the mental health sector. So Kerry, we're looking forward to your contribution to the conversation about points of hope and ways forward. Thank you.
Thank you so much for having me tonight. Can you hear me?
Yes. Oh,
fantastic. So thank you so much for having me here tonight. The work I do myself, there's a team of 6 of us here in Geelong. It's a privileged position to be able to sit with women, particularly when they're sharing their stories of the trauma that they've experienced. And one of our roles is to try and help them navigate through the justice system. The majority of the police and court personnel that we deal with are very interested in supporting women who are victim survivors of sexual assault, but their primary role is to gather the information or gather the evidence required to get a conviction, to get the offender off the streets. And then leading into the court system is obviously to get a conviction and again, attend to the justice sentencing and whatnot. So that is at odds, I suppose, with us in our trauma-informed way. Police are becoming more and more aware of the impact of trauma on victim survivors, and they're doing their absolute best and undertaking training to do that. But at the end of the day, gathering evidence, gathering statements is time critical. So they look for support, they look for ways to do it better, but they do explain that they have a job to do as well, which is, it's a really tight and a really difficult position that they find themselves in. To assist with the victim survivor to, as they enter into the justice system, which none of us actually ever want to be in coming through that door. But there is a victim's charter which outlines the rights that a victim survivor coming into the justice system can expect to be treated with dignity and respect, can be expect to be provided with timely information, correct information. They will be kept up to date about where their court case might be heading. If charges are going to be reduced, for example, through negotiation, if it's a serious sex crime, the victim survivor should and would be notified and have that conversation so it can be explained to them. Once a crime occurs and it's reported to the police and it gets handed up and becomes a brief of evidence, it's no longer a crime against the person. The person becomes invisible in that system. So we try and ensure that the victim survivor continues to have a voice and can continue to participate for as long or as much as they want to do so. There's no doubt about it that there's ongoing systems abuse. So not only does the victim survivor suffer the rape itself or the sexual assault, but then each contact that they have can lead to further re-traumatisation, and the length of time it takes from reporting of a crime to ultimate outcome in court, if it should get there, can take so many months into years. So that continues. People are just starting to rebuild their lives to find the strength to move forward, and then they're dragged back into the system again because there's another hearing or there's another appeal or there's another something. So our role as victim support workers is to continue to be with people. We walk through that path with them every day. We're there for as long as they need us to do what we need to do to help and support them, whether that's through the court processes, with the interviews with the police, doing their victim impact statements, and then also making sure that if there's an incarceration, that the victim survivor can be notified by the parole board or by the victims register that the offender is actually due for release or is coming out or is applying for parole, so that we can then put steps in motion to further protect the victim survivor on the release of the offender. So I might hand over to Sue now, who has been in the Victims Assistance Program for about 7 years now, I believe, and is a dedicated worker to all of the people that come across her path. She has a strong interest and in supporting victims of all kinds of abuse. So I'll pass over to Sue to continue in the conversation.
Thank you, Kerry. And yes, thank you for having me here tonight. I'll be very brief because I know we're running over time, and I think everyone's just about covered what I wanted to say. That's the problem with going last. So I'd just like to highlight, the statistics that Tony and Adele have quoted, are truly shocking and really highlight why we desperately need reform. And, in my experience as, a frontline bystander supporting a victim throughout many trials, the system actually is quite brutal, very traumatising, and very demoralising, and we need to find a way and that victims can be protected, and our adversarial system doesn't do that. The victim's voice is lost. They're left out of the process very often, and it just goes ahead without them. And it's actually, really between the prosecutor and the defence, and it's a competitive, game, really, in my experience. And the most experienced lawyer can often win in creating that element of doubt and in discrediting the victim. And, there's lots of reasons why that happens, and the anxiety of going to court and, what has happened to the victim already, and, having to disclose the most horrible thing that could have happened to you to one person, let alone a whole courtroom, is just, again, I think truly shocking that we ask that. So, I think that the restorative justice is a good option for people that don't want to go down that path. And as Narita said, can be done in a very caring and supportive way. And sorry, I'm waffling now. I also think that the reforms that Tony mentioned, especially educating the judges and having specialised, lawyers and judges in this area, because it's not only the court system and the police, and how victims are treated throughout the process that stops them reporting. It's also, societal myths about rape and sexual assault and, victim blaming and all those things that go with that. And I won't list them all because I'm sure many of you know them. But a dedicated advocate that starts with the victim from the very beginning, from wanting to report that if there was an agency or someone they could contact, like us, the Victim Assistance Program, that we can start with them from the very beginning, right from reporting to police and throughout the whole process, and be the liaison for them, be the emotional support, link them in with other support services, and just, you know, make them feel valued and cared for throughout the process, rather than forgotten and, you know, left to the side until they're needed as a witness, and then they're contacted again. That's really all I've got to say about that. I mean, I've had pages typed up to say, but everyone's covered it. And, you know, if anyone is interested in hearing more about the myth, you know, the myth of rape and sexual assault, there's plenty of information out there. You know, I was actually quite shocked that I did a bit of research, and I can't find it now, but back as early as 2019, people still thought that, you know, rape was mainly by strangers, you know, in a public place or in a dark alley. And, you know, that's simply not true. You know, 8 out of 10 sexual assaults from people known to the survivor. So I'm not sure if Adele had a different statistic. But yeah, so the common belief that the victim survivors, you know, are somehow put themselves at risk of this, rather than, you know, changing the narrative to why do people choose to use violence against women and children. Okay, that's all I've got to say. Thank you very much.
Thank you, Sue, and thank you for being patient, being at the end. I think what you've each managed to do is raise a number of issues behind the shocking statistics that surround these issues for women. And you have generated some questions. So we're going to, they're questions by and large directed at particular people. I'll start with one of the first ones to emerge, which is for Nerida. In relation to restorative justice and the perpetrator perhaps accepting accountability and responsibility for the harm they've done, they are basically admitting to a serious crime. Why would they do this if they feel there's a possibility of criminal proceeding, or does the restorative process negate this possibility? Nerida.
Thank you. Fantastic question. So the first thing that I'll say is that the restorative justice work that we engage in isn't necessarily instead of a criminal justice process. So we do some at various points in the criminal justice system. So it can be where a perpetrator is going to plead guilty, and there can be a restorative justice process at that point. We've also done others, not in relation to sexual violence, but it could certainly happen. And we have offered restorative processes in the context of other crimes after an offender's actually been sentenced. So we've done conferences when somebody is in custody, and that could go ahead. In some cases, so another thing I'll say is that participants agree that what is said and done in a conference process is confidential and can't be relied upon in any subsequent legal proceedings. And I suppose knowing that many victim survivors choose not to report, these can be done where it's understood that this will never be reported to police. We do have a very good relationship with Victoria Police as well, and there are some cases where, you know, and this can be very difficult for victim survivors, but there's just no prospect that the case will proceed. And so the perpetrator understands that as well. So in that context, there is not great risk for the perpetrator that participating in a process will result in, you know, a prosecution that would otherwise have gone ahead. But in terms of their motivation, all I can say is that some people who've caused sexual harm do want to take responsibility, and that's not everybody, but that some people do.
Okay, thanks, Nerida. there's a question for the panel overall, and then a specific one for Tony coming up. For the panel overall, there have been some suggestions that an inquisitorial system would benefit rape or sexual violence victims. Do any of the panelists have thoughts on that? You might want to wave your hand for me if you'd like to have a go at answering that. Tony, I had a feeling it might come to you.
Yeah, well, this was one of the things we looked at because when we understand that these cases are word on word and the standard of proof is beyond a reasonable doubt, you can well understand why juries often have a doubt simply because one person says it happened and the other person says it didn't, or one person says there was consent and the other says there wasn't. So, and I was really attracted to the idea, but the problem we face is that the adversarial system is so utterly ingrained in our system that the practical chance of changing it is so remote that it's not a practical basis for considering reform. Even if it was a good idea. And I'm not sure that it is a good idea because even in an inquisitorial system, you need to get the evidence of the complainant somehow, and that's always going to be a difficult exercise. So what we were told was a better way forward is to try and soften the way the adversarial system works. And when you see our roadmap, I think you'll see there are things that can be done. I mean, we last reported in 2004 on this very subject matter, and a lot of reform has happened in the years since then. Sadly, not a lot has changed in the metrics, but I think that we are at a moment in history with the Brittany Higgins and the Grace Thames and the Harvey Weinsteins and the whole last 12 months or 18 months has built up a pressure that really requires government to take on board a whole lot of quite, important reforms. And, for instance, one thing we've seen as a result of COVID is that complainants have given their evidence on video very close to shortly after the events happened, so that trauma of having to wait for 12 months for a trial to come on is eliminated because their evidence is filmed, examination, cross-examination, re-examination, and it's played at the trial. So, you can do a lot with educating the legal profession and implementing all these sorts of reforms. And I think to be realistic about it, you're better looking at ameliorating the sharp edges of our adversarial system than trying to radically alter. And then, of course, I have to say that the adversarial system has as its basis the strong requirement for a fair trial. So, people always say to me when I go off on the inquisitorial line, they say, well, if you were charged, wouldn't you want the Crown to have to prove the case beyond a reasonable doubt? And there is a point about that. Fair trial is a very deeply ingrained part of our legal system and, not likely to be changed tomorrow.
Okay, thanks, Tony. I think that answers one of the other questions that was directed towards you. There's a question that is for you, but I think is relevant to some of the other panelists as well. I like the idea of victim advocates. Does Tony see this working in Australia, and how does he see it working in Australia? I suspect it would be interesting to get Kerry and Sue's view on that as well. So Tony first, and then fairly quickly Tony, and then Kerry or Sue might like to pick up that point, and then I think another couple of minutes and we'll need to round the evening off. It seems a pity to cut off conversation, but I suspect we could be here for quite some time to come. So Tony, very quickly.
There was very strong support for the idea, very strong support, and I think it would look very much like what Sue and Kerry say that they do. It would just be, I guess, you know, wound out more widely, funded by government, and become, you know, institutionalized, so that it would be an expectation for every victim survivor right at the point of report to have this person by their side.
Okay, thank you. Kerry or Sue, would you like to make a quick comment?
Yeah, I think what Tony said would work really well. You have specialists trained, you know, specially trained people, yeah, and from start to finish, and then support afterwards, because currently now, often we get referrals, but it's halfway through the process, or, you know, but at the end, when the person's, you know, severely traumatised. So I think that victim advocate, you know, which is similar to what we do, would be a very good support for people, and change, perhaps, you know, assist the police, assist the prosecutors, you know, all working together, but with the prime focus on supporting the victim, explaining things, you know, making them feel included in the process.
Thanks, Sue. We have a couple of questions coming up that particularly relate to victim experiences, and I do want to put those to the panel. Perhaps if one of you could indicate who'd like to address them. When a survivor of first reports her assault, what advice can you give her when dealing with the police? For example, should they have three main people they deal with? This is clearly a specific experience. Kerry, thank you.
The first thing the police should be doing is making sure that appropriate referrals were made for the victim survivor, whether that be through to the SAF centre or
which centre for those?
Sorry, the Sexual Assault and Family Violence Service, which is the primary report function for sexual assault and family violence for females. Victims Assistance Program gets the L17s or the police reports on male victims of family violence. Because the police can only make one referral to a support service, all female victims of family violence or sexual assault are sent through to the SAF centre, the Sexual Assault Family Violence Centre. That doesn't necessarily mean that they are then referred out to us to provide the additional supports that we offer as our specialty. So ideally, police would either advise the victim survivor that we do exist and provide contact details for us, because we do sit in police stations around the state, or if they're referred to a female-specific family violence service, that they are then helped, or, you know, either supported with a warm referral or are provided with details so that they can get in contact with us. We can help, as Sue has outlined, we can help walk victim survivors through the justice process, from taking a statement right through to the end of the justice process. But we can't do it if we don't know about these victim survivors. The worst thing for us is when we pick up a newspaper. In the old days, we're reading online, we hear on the news the story about someone who's been in court and they've had no support during that process. There is absolutely no reason for that. We are available, there is support services available. So in that case, anyone reporting a crime should automatically be provided details for victims assistance.
Thanks, Kerry. And it's another one that I do want to take a moment to ask. The burden of proof is particularly difficult for victims, survivors of long-term child sexual abuse, especially survivors who seek justice as adults. There are accusations of false memories and a lack of ability for the criminal justice system to acknowledge the reality of repressed memories and complex PTSD. Can any of the panelists address this? It's such a complex issue, but if someone could just make a helpful comment in relation to that. Anyway, Tony?
Yeah, one of the things that we looked at, and you'll see in the report, is the use of experts in rape trials. And this would be an area where an expert, the experts are not used often in Victoria at all. They are in New Zealand. It's common practice. I think part of the answer to this question is the more use of experts in rape trials. And what we heard about was establishing a panel that could be called upon at short notice of experts in particular aspects like delay in reporting or, you know, well, and in fact, you know, repressed memory, I think, is probably pretty much a past argument now. I don't think it's relied on so much as it used to be, but it would be an area where experts should be able to inform the court. A court where barristers and judges have specific training, as I talked about before, would probably be equipped even without an expert to guide a trial much better than happens now.
Thank you. A final question, because it's a question around a point of hope and where to next, and it's directed to Adele. As members of the union movement and strong advocates for women's rights and equality, what do we see as the next steps?
Thanks, Glenda. So I think a really key step is addressing the culture that violence against women sits in. So the lack of respect for women and the work that women do that I mentioned earlier. Obviously, lobbying and advocating for systems change. I really like Tony's idea of training for judges. But I think as well, things like addressing the gender pay gap, making early education and care free and accessible for women, raising Centrelink payments and pensions, making sure that women have got access to affordable housing, because one of the things that we really know is lack of access to financial resources is a key factor in women returning to violent situations. So I think we just really need to address all those systems that I guess keep women oppressed and disadvantaged and impoverished, and make sure that women have got the financial resources that they need to live a free and independent life.
Thank you, Adele. Tony.
Glenda, could I'm
yes.
Sorry to keep having more to add, but there is something really, I think, important that came to us in the inquiry apropos what Adele just said. You know, what has been proposed is to change the law so that employers have an enforceable obligation to ensure, like they have at the moment in relation to sexual harassment, to have workplaces free of sexual violence. And what was proposed to us is that, unlike at the moment where it's just an obligation without any enforceable ability on the Victorian Equal Opportunity Commission to do anything, what we heard was expand it to cover sexual violence, not only harassment, and make it enforceable so that employers can be, you know, notices can be served, and I dare say workplaces closed down, and have a liability on employers, so that, you know, that's the way of forcing this culture through society in ways that sort of mean something, rather than us keeping banging on saying, yeah, we want culture to change. I mean, I think, you know, I think you'll be excited by our roadmap, because you can see the breadth of the coverage of what we will be recommending. All these various, you know, areas where there is a chance to make things better, we've covered off on.
Thanks, Tony. I think we will draw it to a close now. Can I just say a huge thank you to Adele, to Tony, to Narita. I can't see her on my screen. There she is with her lovely daughter by the look of it. Kerry and Sue for sharing your knowledge and experience, but more particularly for looking at points of hope for how we move forward and make changes. And I think with that thought in mind, Adele, I might do a plug for the Geelong Women Union Network, because that's a point of pressure in our local area where other women can clearly join in and contribute to moving the conversation forward. I know when I first talked with Nancy Donkers, who's a member of the network and who was very keen for this process to begin, Nancy was hoping for the conversations to grow around what we can do to create change, not just talk about what's wrong with the system, but how we produce points of positive change in the system. And I think each of you have been really important in showing pathways to what that might look like. Tony, I'm sure everybody is going to be wanting a copy of that report the moment it's public, and also clearly advocacy will still be needed to create changes. Even though the report will make recommendations, they often need a lot of support behind them. So thank you everyone for staying with us tonight. We are a little running over, but you can hear the range of issues that need to be addressed and the points that need to be thoughtfully engaged with as we move to make the world a safer place for women. So thank you all. We'll sign off, and thank you for all the participants who stayed with us through it. So bye from Tony. Yeah, Narita, Kerry, Sue. Thank you one and all.